Excuse me, I'm gonna have to check your bag because you're wearing all black and that looks very suspicious.
Do you have a warrant or probable cause?
No.
Then that violates the Fourth Amendment. It protects me from any unlawful searches or seizures.
The Fourth Amendment?
Yeah. Let's take a look at the history.
For a couple of reasons. Prior to the founding of the nation in England, there had been these general warrants that allowed the police a lot of discretion to search people's houses and homes. And when we came over into colonial America, there were writs of assistance that allowed the police to essentially do the same thing. And the founders did not want that kind of unfettered police discretion, right? They wanted to rein in what the police could do. And so the language you just read says two things. It says we have the right to be free from unreasonable searches and seizures. And it says that if you're going to get a warrant, you got to base that warrant on probable cause, and you absolutely have to say specifically where you're searching and who you're looking for and what you're going to seize and what things you're going to seize. And those two clauses have been read together. So for the most part in modern history, with some exceptions in more recent years, for the most part, we have said that warrantless searches are unreasonable. So if the police don't have a warrant, they haven't gone to a judge and sworn out an affidavit and said, this is where I want to search and this is what I'm looking for with some particularity, they can't search. That was the general rule.
Oh, that makes sense. Does the Fourth Amendment have anything to do with the Utah versus Strife case?
Yeah, actually that was a huge debate that happened in 2016 in the state of Utah. Let's go and look at some of it.
Today I'd like to talk to you about the latest U.S. Supreme Court case of Utah versus Strafe. Now, typically what happens is, let's say that you're driving and the police pull you over and they have no reason to pull you over. In other words, you haven't violated any traffic law. So there's no reasonable suspicion of any wrongdoing and there's no probable cause. If the police pull you over for no reason at all and they search your car, then anything that they find is excludable under a doctrine called the fruit of the poisonous tree doctrine, which means that it's not admissible in trial against you. So if the police find drugs in your car, then they can't use that against you, even if you admit that they're your drugs, because the stop was illegal. It violated the Fourth Amendment. Now, the case of Utah versus Strafe is a very peculiar decision. In my opinion, it's a terrible decision. Here's what happened in the Strafe case. A gentleman in Utah was walking outside of a house where there was suspected drug dealing going on. A police officer walked up to Mr. Strafe and said, hey, I want to talk to you. Mr. Strafe didn't want to talk to him, but the cop would not let him leave. Even the state of Utah, in arguing before the U.S. Supreme Court, conceded that it was an illegal stop. In other words, the officer didn't have probable cause or any reason to detain Mr. Strafe. Now, during that time, while he was detaining him, he called down to the headquarters and they ran a background check and determined that Mr. Strafe had a warrant out for his arrest. He was taken and booked, and during that search incident to arrest, when he was booked into the local jail, they found contraband, which they used to prosecute him with. So he was charged with violating a felony possession of controlled substance law in Utah. Now, the lawyer that he had argued, rightfully, that the drugs should be suppressed as a fruit of the poisonous tree under the fruit of the poisonous tree doctrine because there was no basis to stop Mr. Strafe, and therefore anything that was found after the illegal stop should be excluded. Well, Utah took that up to the U.S. Supreme Court, and the U.S. Supreme Court said, well, in this case, because there was a warrant, that's an intervening factor, and because there's a warrant, then it excuses the unconstitutional action on the part of the police officer who stopped him for no reason at all. And they said that the drugs were hence admissible. It's a terrible decision because so many people out there have warrants for their arrest for minor things like just traffic tickets or parking tickets. And it's scary to think that an officer can walk up to you, detain you illegally, and then under the guise of checking to see if you have a warrant, decide that he's going to arrest you if in fact it turns out that you do have a warrant, and everything on your person is now the subject of an admissible activity against you. So if you're in a situation where you have an active warrant, make sure you retain an attorney, either me or any attorney, to quash those warrants because you don't want to be in this situation.
I remember seeing that on the news, actually. Question, how do you get a warrant?
That's a great question. Let's take a look.
For law enforcement to obtain a search warrant, they have to prepare an affidavit which sets forth probable cause, allowing a detached and neutral magistrate to review that and find that there's a legal reason that a search warrant should be issued. If that warrant affidavit does not properly set forth legally sufficient probable cause, then any search warrant issued by a magistrate is an illegal search warrant. And anything that's obtained by that illegal search warrant cannot be used in court.
Oh, now I understand how to get a warrant. Is there anything else I need to know about the Fourth Amendment?
Well, the other thing is for police to be able to search someone, they have to have a warrant, which we just learned about, or a probable cause. And for a probable cause to exist, a police officer must have sufficient knowledge or known fact that a suspect is committing a crime, not just based off suspicion.
Oh. Well, thanks. This has been very insightful.
Of course, no problem.
I'm sorry.
It's okay, no worries.